You are listening to lawwithdenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your host is Denise, your experienced law teacher sharing knowledge on various areas of law, including contract, torts, the English legal system, and criminal law. Understand the law better and learn the skills you need to get the grades you need.
Hi, welcome to the Law with Denise podcast. My name is Denise and you are listening to episode 005. In this episode, I will be making comparisons between the Neighbour test or Neighbour principle, the ANS test, and lastly, the Caparo test. Now, these are all tests that have been developed and used in the courts to determine whether or not a duty of care should be imposed. We'll start off with a neighbor principle, the Neighbour test. Now, most of you should by now know that the Neighbour test was developed by the House of Lords in the Donoghue and Stevenson decision in 1932. And the Neighbour test told us that if there is sufficient proximity between the defendant and the claimant, and if it was reasonably foreseeable that the defendant's actions or inactions would lead to the injury in question, then a duty of care would be imposed. So we got two concepts out of this Neighbour test or Neighbour principle. One was proximity, that is proximity between the defendant and the claimant. And then there was also this concept of reasonable foreseeability. Now, what was the purpose of this test? This test was a test that judges would then use in courts whenever there were novel situations in front of them. So cases with brand new facts that they had never seen before. So a new type of claimant or new type of defendant or just a brand new scenario. How would they decide if a duty of care was to be imposed? They would use the Donoghue and Stevenson case or the Neighbour principle or Neighbour test. Ask these questions of reasonable foreseeability and proximity, and if the answers were yes, then a duty of care would be imposed. Now that is it in theory, but what happened in practice? In practice, it seems as though judges were reluctant to use the Neighbour test. It seems as though judges were focused on finding precedent in order to, before they impose a duty of care. It seems as though the main trend after the Donoghue and Stevenson case was to ask those questions of reasonable foreseeability and proximity, and if the answer was yes, only impose a duty of care if there was justification for it. And usually that justification would have been or was found in policy reasons. So when I say policy reasons, I mean that the judges would justify this imposition of a duty of care because they felt that for some reason, if they impose this duty of care, it would benefit society. How did people react to this hesitation by the courts? How did people react to this reluctance by the judges to use the Neighbour test? Some felt that this reluctance or hesitation by the judges to use the Neighbour test more frequently was hindering the development of the law. And in response, we had Lord Reid in Home Office and Dorset made a comment stating that the Neighbour principle should be applied unless there was reason not to apply it. Then later on, in another case by the House of Lords, in what we call ANS and Merton London Borough, we were given what we now know as the ANS test. The ANS test said to us that the Neighbour principle would be applied, but it would be applied in a different way. So remember I said that up until this point, the judges were reluctant, they were hesitant, and they were only applying it really if they felt it justifiable to impose a duty of care. But with this case, or with this new test, the ANS test that the House of Lords gave us is in Anns and Merton, London Borough. What they were now told would happen is this. You would ask this question of reasonable foreseeability and proximity. And if the answer was yes, there was reasonable foreseeability of the injury in question being caused if the defendant did not do what he was supposed to do, or if he did it carelessly. And if you ask the question of, is there sufficient proximity between defendant and claimant, and the answer is yes, so you have yes, the court said we are going to impose a duty of care unless there is reason not to. So before the ANS test, there is a question of, we still ask the same questions, reasonable foreseeability, proximity, yes. But hold up. We're only going to impose a duty of care if we as judges feel that it is necessary or it is justifiable to impose this duty of care. But with the ANS test, the attitude, the approach is somewhat different. We're asking the same two questions, but the judges are saying, if our answers are yes to reasonable foreseeability and sufficient proximity, we are going to impose a duty of care unless there is some reason why we should not do it. Now, what was the consequence of this new ANS test that the House of Lords gave us? Well, one of the consequences was that there was an expansion of the amount of areas in which a duty of care was imposed. And later on, there was some concern about this widening of the scope. There was fear that there would be too many floodgates. We would open the floodgates. We would have too many people entering the courts, bringing cases to the courts. And because of this very wide open test, that it would just get out of control. And there was a retreat from the ANS test in the case of Murphy. So the court said, we are going to overrule the ANS test. We are going to overrule it. We are not going to apply that ANS test anymore, that two-stage test. We are not going to use that anymore. They said they recognize that what we need is an incremental test, and we do need to bear in mind precedent. We cannot just look at the facts in front of us and say, oh, is there reasonable foreseeability? Was there sufficient proximity? And then think, oh, we're going to impose a duty of care unless there is some reason not to. They said we need something different. And that something different was given to us in the Caparo case of 1990, decision from 1990. That is where we get what we call the three-stage tear test, three-stage tear Caparo test, or the three-stage Caparo test. That is where we get it from. So in Murphy, we were told ANS is no longer applicable in our courts. The House of Lords overruled their own decision. And then in the Caparo decision of 1990, they told us this is what we are going to use. We are going to use this three-stage test from now on. Now, what is this three-stage test? This three-stage test is somewhat similar to the Neighbour test and the ANS test because it is still concerned with reasonable foreseeability of injury, and it is still concerned with proximity between claimant and defendant, or the relationship of proximity between claimant and defendant. But it asks one other question, and that other question it asks is it fair, just, and reasonable to impose a duty of care in this situation in front of us? So the ANS test didn't ask that, nor did the Neighbour test. But the Caparo test lays it out clearly that these are the three questions we are going to ask. And it makes clear that with this last question, judges should look at or involve themselves in factual analysis in order to determine whether or not they should impose a duty of care. So it's a stricter test, a stricter test in comparison to the ANS test and the Neighbour test, and it is a three-stage test, and it is applied step by step. So there you have it, a quick comparison of 3 tests from the Neighbour principle or the Neighbour test that we got from Donoghue and Stevenson in 1932, the ANS test we got in Anns and London Merton in 1978, and the Caparo test that we got from the House of Lords again in 1990. I hope that was useful. Thank you.
You've been listening to lawwithdenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your experienced law teachers sharing knowledge on various areas of law, including contract, tort, the English legal system, and criminal law. If you like the content, please remember to like, share, and comment. Thank you.